So good day to you, sir.
Thank you. How are you?
I'm very well, sir.
Right.
Yes, sir. Can you please introduce yourself to our audience?
Yes, I'm Honorable Justice Oyejide Falola.
Do you mind telling us how it started, your journey?
Basically, I attended University of Ibadan, where I picked 2 degrees, one in guidance counseling and one in law. Thereafter, I ended up in Nigerian Law School in 1991. So along the line, I practiced as a lawyer for a couple of years, about a decade. And then I was employed as a magistrate. I spent about 7 years before I was elevated to uh, become a high court judge. Early in life, I ventured into teaching and school counseling before I upgraded to career in law. So, in the course of my job in the judiciary, I have trained severally as a mediator and arbitrator in various institutions in America, in Nigeria. I was in Kennesaw State University in US. I was in New York for a course in international dispute resolution. I was in Dubai, UAR, a course in mediation too. And then at the Nigeria Institute of Chartered Arbitrators, I have just mediation and arbitration. And like I said, I did training, guidance counseling, legal practice, and then judicial activities. All these, they complement one another, and they are rooted in mediation, resolution of disputes, which is more preferable to stabilize the society, which is education is very expensive. It costs time, it costs money, and people go there to battle themselves out, unlike in mediation and arbitration, where the end goal is to ensure that disputants are brought together in a more friendly manner, and then in a confidential environment which is not exposed to the public, so that people get issues resolved, especially people in business.
For mediation,
Yes.
it involves 2 parties to mutually agree.
Right.
How do we compel the other party to be a part of the mediation process instead of going to court?
Well, that's why I said ADR is a new concept. It is old, but it's not popular. People are now seeing the beauty of it. With regards to mediation, one of the parties has to signify his intention to approach the other party to consider exploring the possibility of resolving the disputes. Once it is initiated by the first party and the other party agrees, Nigeria, you can no longer withdraw once you submit to
a mediation process.
mediation process. Once you submit, and then the law is activated, then the process has to continue. Even if you fail to continue, the process would run to its full course.
And whatever decision you made,
Yeah, it has to be implemented. Yes.
Mediation is known for being cost effective and generally faster than litigation. But what do you say if will it not be less effective if a party dominates the process?
Well, we call those who facilitate mediation as neutrals.
Neutral.
Experts who are trained in bringing parties to amicable settlement of disputes. And don't forget, it is not a universal, it doesn't have universal jurisdiction.
Okay.
Mediation, for example, divorce is exclusive to High Court. Criminal matters are exclusive to criminal courts. Even though mediation can come in to bring parties together and then allow the court to take final decision. But once the parties agree and the law takes its effect, don't forget I mentioned the applicable law now. The terms of settlement will be drawn up. The parties will execute it, will sign it. So also the neutral that facilitates the process will also sign it. And then it will be taken to a court of law. And it will be filed as consent judgment. So it becomes executory. It becomes the judgment of that court. So if any of the parties reneges to play its own part in the agreement reached, then the court can activate its awesome power of coercion through the court registrar, the belief, and the process of executing judgment will now take place. Yes.
Okay. So you have spoken about the equivalent. Which part of should I say level of court, maybe High Court, Court of Appeal, is equivalent to a mediation decision?
Yes, it is filed once the decision is reached. It is filed at the High Court.
Okay.
And it becomes the judgment of that court.
Okay.
Yes.
But if a party does not agree with the decision, it can be appealed?
Well, it can't. For the fact that the two parties, by consent, agree to go into mediation. Once the decision is taken by the facilitator, by the neutral, that is final. The only aspect where the court can question the decision is maybe there are technical defects in arriving at that decision. Probably like denial of fair hearing, or that the subject discussed is not justiciable. So,
okay, I have a question here.
Okay.
Now, mediation,
yes,
it is known for its control and flexibility, because both parties can control the outcome and process.
Yeah.
And the time, of course, the timeline, because it is time effective.
Exactly.
Okay, but it may end in impasse if the parties don't agree. What if they don't agree on the outcome? The both like a party does not agree with the outcome. Okay, now this is an outcome, but at the end of the day, I disagree to sign to the outcome of the mediation. Does it not render it null and void?
Oh well, the moment they subscribe, like I said, It's an agreement between parties to enter into the mediation process, and it is party-centered. Once you volunteer to go in and the law applicable is activated, it used to be that parties have discretion to obey or not to obey. But with the advent of the new law, they have no choice. The discretion is whittled down. Once you agree to enter into the process, you cannot go in midway because the thing is running against you and you withdraw.
Okay.
No.
For someone to be a mediator, what does it take?
Well, you need to be equipped professionally.
Okay.
There are institutions in Nigeria that train mediators, just like outside the country too. We have Institute of Chartered Mediators and Arbitrators in Nigeria. We have Nigerian Institute of Chartered Arbitrators in Lagos. We have Chartered Institute of Arbitrators in Abuja. And then in UK, all over the world. So you have to go in and obtain a certificate. You have associate certificate. You have membership certificate. And then you crown it all with fellow, which is the highest stage.
So
Yes.
before, what are the cases that mediation can look into? Like examples of cases.
Mediation sets out to resolve disputes and stabilize the society, essentially. And so it covers various fields. Land dispute, for example. People go into contract. People who have other personal disputes, maybe bank and customer disputes, and rent, property, child custody, like couples going for separation, and every other aspect where people feel aggrieved, and they feel they can approach experts who are equipped to resolve the dispute between them outside the publicity of the court environment. People just walk in, and then some cases in court which last 17, 20 years, within 2-3 hours, the mediator can resolve the dispute for the parties. And then they go away in different ways.
You mentioned while citing instances of mediation cases now, you mentioned contract. Isn't that false? Isn't that supposed to be about this cotervary clause, which are usually in contract for arbitration? Can mediation also undo?
Yeah, there is no clear-cut boundary between mediation and arbitration. Like myself now, I train as an ABMED. ABMED. That is arbitrator and mediator. I combine the two. A lot of people do that as well. In fact, most arbitrators, they have background in mediation. Most mediators, they take courses in arbitration as well. So essentially, arbitration deals with contract, business. The founders of arbitration, they feel that they are businessmen, and their business, in order to succeed, does not have to waste time
Time.
in resolving disputes. So that's why it revolves over time, that parties will just get people who are trained and present their cases before them, and then they get resolved. In the striking difference in mediation and arbitration is that most of the contracts, either between companies or companies versus government, or government versus government, or government versus individuals,
Okay.
is that the agreement usually contains what they call arbitration clause.
Okay.
It usually says before you go to court, you must explore arbitration first. Whereas in mediation process, such clauses are not usually included in the agreement. The agreement may be oral, this and that. So you have to go into arbitration first once there is that clause in the agreement. Even if they go to court and the objection is raised that, court, look at this portion, then the court has to hands off and direct the parties to go back to arbitration.
Now,
Yeah.
if they go back to arbitration,
Okay.
and either of the party does not agree with the decision of the arbitration, can they appeal? Is it appealable?
The decision of an arbitrator is final.
Okay.
The decision rendered on merit is final and not appealable. That is why it is preferable than court, which has layers and layers of appeal. When a decision is rendered by an arbitrator, that decision is final. The only area where it can be questioned, just like in mediation, is if, for example, the decision falls outside the agreement of the parties. Like, for example, there is denial of fair hearing, or probably one of the parties
As interest.
it has no jurisdictional competence to enter into agreement in the first instance.
Okay.
Maybe it's a junior, it's a minor, or does not have intellectual capacity. Things like that can be explored, but you cannot question the merit, the decision, you cannot question how the mediator arrives at his decision. But it's assumed that it is well trained, is a person of integrity, and is a person that knows his onion, very objective, and is bound to give accurate decision.
Okay. Then, according to New York Convention,
Yeah.
arbitration decisions are universal.
Yes.
Why should a party go into such a process when there may be a fear of fair hearing, or any other instance? Maybe the party is of interest or is passionate about the case. Maybe they know the family members or something, like, and it is universal. Why should a party go into such a process when it is not appealable?
Well, before the process is initiated this way, once there is a clause of arbitration in the agreement, it will spell the number of arbitrators, whether one or two.
Okay.
Or one, or it's usually one or three. If it is three, each party will nominate one arbitrator, and then the two arbitrators will nominate the third arbitrator. Okay. So that was, it is a party-centered operation. I can call it as a private judging.
Yes. Okay.
Private judging.
Confidential.
So all of them, once they, out of their own free will, they nominate those arbitrators. So they cannot now come back to say that they don't like that decision again.
Because they are a part of the process.
Yes. The only issue along the line is that there is what they call disclosure in the process of arbitration. Like you said, the member of a family, this and that. an arbitrator must disclose if he knows any of the parties, if he has come across that case, that matter, that dispute brought before him, or he has something that may be beneficial to the two parties, so that he will explain everything, his status to them. It is for them now to say that we know you, we can tolerate all these things you are saying. Notwithstanding that you are a schoolmate to this guy, notwithstanding the fact that you hold a minor shares in this company, we know that it will not affect your judgment, your decision. We can tolerate it. So, and if any of the parties, before the process commences, if any of the parties has objection about the fairness or the background of the arbitrator, he has right to raise it. But the moment he fails to raise it within a reasonable number of days, in some instances like 30 days, so that is the end. It will be taken as an afterthought. And like you said, an arbitrator is his decision is universal. Unlike in court process, like where you have Osun State High Court, or your State High Court, or Federal High Court, whose jurisdiction is just within a particular restricted territorial area, like a state or a country. An arbitrator has the world at his feet. So once his decision is rendered and it's in line with the established law and the agreement of the parties, that decision can be executed in any part of the world where the property of the loser is.
This is a very, very great initiative, personally, because I think most Nigerians are not aware of this, and that's why we spend years in court.
That is true. That is true. Initially, the problem which ADR has is that some lawyers, they have the view that it will deny them of revenue if a case is completed within a very short length of time, or the parties will just come in and walk away just like that. Whereas this archetypal style of legal practice, where people hold on to case files for years, you discover that in some land matters or chieftaincy, those who commence the matter
have died before.
Yes, their generations will end it. Before a case travels from High Court to the Supreme Court in Nigeria, there is no way it can be less than 20 years. Especially land dispute and chieftaincy. Even contract. Why? Because there are some inherent issues there. You file papers, the other party will file papers, public holidays will come in, and then the law now gives you the number of days you have to file those papers. 30 days for you to file, 50 days for the other party to reply, and then for you to reply again. And then there are lots and lots of cases, and the judges are not so many. And the environment of some courts do not allow or permit the judges to work to their maximum. So cases continue to pile up to the Supreme Court. Usually when you approach the Supreme Court today, the next 10 years, your case may not be heard, because we have just one Supreme Court in Nigeria. And they work almost 24 hours, and the cases keep coming. You know, look at the number of high courts in Nigeria, look at the number of federal and state high courts, court of appeal, and then you have just about 20 or 21 judges to handle all these cases.
Supreme Court in Nigeria should be divided.
I'm not retired yet.
Okay. As an honorable justice,
okay,
do you think Supreme Court in Nigeria should be divided into two, in the way that, or three, in the way that each Supreme Court handles or caters to the cases within their region, like a Southern Supreme Court and a Northern Supreme Court. For EC,
I think the most reasonable aspect of people's thinking is to apply that American approach. They have federal Supreme Court, which handles federal cases and constitutional matters, whose principle is applicable all over Europe, all over America. And then they have states. The states too, they have High Court, they have Court of Appeal, and they have Supreme Court for that state that handles their matter. Look at it now. Somebody is fighting over a plot of land in Odeumu. And then after High Court of Osogbo decides the matter now goes to Court of Appeal Akure. At the Court of Appeal Akure, you have three their lordships.
Okay.
Justices of Court of Appeal. Somebody from Benue, somebody from Rivers, somebody from Kano. It becomes difficult for them to know the land tenure system of Odeumu, where that one plot of land they are fighting over is. And then they jump over, even though they can apply the general principle of law, but the actual brass tacks of what it entails, in some cases are situation specific.
Okay.
Chieftaincy matters. Even in Osun State or in Yoruba land generally, there are various systems of chieftaincy, ascendancy to the throne, the Ibadan style, the federal, and then they run to the apex. Each of them will have their own Supreme Court. The alternative is to reduce the number of cases that go to Supreme Court. It is not every matter, chieftaincy, politics, criminal matter, divorce, everything goes to the Supreme Court, which should not be. Most of them ought to end at the Court of Appeal. Nigerians should have confidence in the judicial system, that if a decision is rendered by the High Court, even if there is a mistake, Court of Appeal is there to correct, and that should be the final. It's only where the law is recondite, there is a new concept in law, that one can now go to. Not that people will now still go to Supreme Court and be establishing facts. Facts should end at the Court of Appeal, and it will reduce the workload of the Supreme Court, and it will reduce the number of years spent on litigation. There are so many Court of Appeals all over, and they can easily handle these cases faster.
Yes.
Especially when if each state has Court of Appeal, or even if with the present unitary system of adjudication that we have, if Court of Appeal can be established in each state, like Osun doesn't have now,
yes.
If each state has a team of Court of Appeal, the cases will be
ending.
Will be faster.